welcome colleagues, Minister, invited guests, members of the general public who are following today's proceedings of the Standing Senate Committee on Legal and Constitutional Affairs. We have a very crowded room today, as you can all see. Anyone who is standing, perhaps, or anyone who is joining us and coming through the doors, we do have an overflow room off to the side where you can view and listen to the proceedings. So you may find it a little more comfortable over there if you wish to move in that direction. Today we begin our consideration of Bill C-16, an act to amend the Canadian Human Rights Act and the Criminal Code. And with us today, to start things off, the Honourable Jody Wilson-Raybould, the Minister of Justice and the Attorney General of Canada, and joining her at the table are from the Department of Justice, William Pentney, and Deputy Minister of Justice and Deputy Attorney General of Canada, Laurie Wright, Assistant Deputy Minister of Public Law and Legislative Services Sector. So thank you all for being with us today. Minister, the floor is yours.
Thank you, Senator, and good morning to all the honourable senators and everybody that is here. I am thankful to be given the opportunity to present to this committee on Bill C-16. And in my remarks today, I will be outlining the broad objectives of the bill, explain the specific amendments that are being proposed within it, and then respond to some questions that have been raised about the bill. And at the close of my remarks, of course, would be very pleased to take questions from the honourable senators present. So Bill C-16, an act to amend the Canadian Human Rights Act and the Criminal Code, is an incredibly important step in protecting the dignity, security, and freedom of trans and gender diverse Canadians. These individuals, like all of us, deserve equal protection under the law so they can make for themselves the lives that they are able and wish to have. The premise of Bill C-16 is that all Canadians should be free to be themselves, without fear of discrimination, hate propaganda, or hate crime. Sadly, this is not yet the experience of many trans people in this country. As you are all aware, trans, gender diverse, and two-spirited persons face elevated levels of violence and risk of violence, including physical and sexual assault and verbal, physical, and sexual harassment. They also face significant obstacles in obtaining and advancing in employment, and not because of a lack of qualification. Yet our human rights protections and criminal law do not explicitly protect this vulnerable group. With this bill, Parliament has the opportunity to affirm in clear language that trans and gender diverse persons are entitled to equal protection from discrimination, hate propaganda, and hate crime, and that all Canadians are entitled to manifest their gender identity and gender expression without fear for their safety. Canada is strengthened by its diversity, and this diversity succeeds best when our laws and institutions promote social inclusion and participation for all. This is fundamentally what this bill is about and supposed to do. To this end, Bill C-16 proposes to make 3 amendments. First, it would amend the Canadian Human Rights Act to add 2 prohibited grounds of discrimination: gender identity and gender expression. As a result of this amendment, it would be a prohibited discriminatory practice to disadvantage people because of their gender identity or expression in matters of employment and the provision of goods, services, facilities, and accommodation customarily available to the public. While the Canadian Human Rights Act only applies within a federal jurisdiction, every province and territory has now passed or introduced similar amendments to their provincial human rights legislation to protect trans and gender diverse persons from discrimination. This bill would be the final piece of the puzzle in ensuring full protection for trans and gender diverse persons across the country. Second, this bill also proposes to amend the Criminal Code. It would expand the list of identifiable groups that are protected from hate propaganda by adding gender identity or expression to the list. And finally, it would clarify that hatred on the basis of gender, identity, or expression should be considered as an aggravating factor in sentencing for a criminal offense. This is not the first time that the Senate is studying this issue. In the 41st Parliament, this committee considered Bill C-279, a very similar bill. As mentioned, all provinces and territories have either passed or introduced similar amendments to their own human rights statutes. And in light of this, I believe these amendments are long overdue. Nevertheless, it is evident from debate in the Senate that there are questions about why we need to enact these amendments and what they will do. I would like to address some of these questions now. Some have wondered if these amendments are necessary. It was pointed out that trans persons may already bring a discrimination complaint using the ground of sex under the Canadian Human Rights Act, and that the hate crime sentencing provisions of the Criminal Code is open-ended and would already include gender identity and expression. Allow me to offer 3 responses to the argument that the bill is redundant. First, all Canadians should be able to turn to our fundamental laws, like the Canadian Human Rights Act and the Criminal Code, and see their rights and obligations spelt out clearly and explicitly. Promoting access to justice means working on an ongoing basis to make our laws clear and as easy as possible for everyone to understand. While tribunals and courts have dealt with some complaints from trans and gender diverse individuals using the ground of sex, we should not expect ordinary Canadians to infer that gender identity and expression are covered by this term. Trans and gender diverse people who feel that they have been discriminated against should not have to become experts in legal interpretation and human rights jurisprudence in order to advocate for their basic rights. Furthermore, employers and service providers should know explicitly what legal duties they have towards their employees and customers. Adding these grounds to the Canadian Human Rights Act, as well as the Criminal Code, will ensure clarity and consistency. Second, Canadians expect parliamentarians to speak on their behalf to the social issues of the day and to affirm their basic values and fundamental rights. With this bill, Parliament has the opportunity to affirm that all Canadians should feel free to be themselves. Parliament can stand with some of the most vulnerable individuals in this country, trans and gender diverse persons, and affirm their equal status within Canada. This is more than a symbolic gesture. This is about embedding new language of respect and inclusion into 2 important laws that affect how we conduct ourselves on a daily basis. Finally, this legislation will also fill an important gap in the criminal law. The Criminal Code's hate propaganda offences currently extend to the ground of sex, but there is no mention of gender identity and expression. As you know, gender identity is not the same characteristic as sex. Because criminal prohibitions are interpreted narrowly, it is important for Parliament to legislate explicitly on this point in order to ensure that the offence protects against hate propaganda, which targets trans and gender diverse individuals because of their gender identity or expression. Next, some senators have also expressed their concerns that this legislation has implications on freedom of expression, and that it will compel certain kinds of speech, such as the use of gender-neutral pronouns instead of he or she. To answer these questions, it is essential to distinguish between the amendments to the hate propaganda provisions in the Criminal Code and the amendments to the Canadian Human Rights Act. The Criminal Code's hate propaganda provisions target extreme and dangerous speech that advocates genocide against an identifiable group, willfully promotes hatred against an identifiable group, or incites hatred against an identifiable group in a public space likely to cause a breach of the peace. Currently, the term identifiable group means a section of the public distinguished by color, race, religion, national or ethnic origin, age, sex, sexual orientation, or mental and physical disability. The Supreme Court of Canada ruled in the 1990 case in R and Keegstra that the offence of willfully promoting hatred against an identifiable group in subsection 319 sub 2 of the Criminal Code was a demonstrably justifiable limit on the freedom of expression. The court ruled that hatred meant only the most intense form of dislike. And to quote from the judgment, quote, "The term hatred connotes emotion of an intense or extreme nature that is clearly associated with vilification and detestation," end quote. This is far from the expression of religious faith, dissenting views, or even opinions that some may find offensive. With regard to the language of willfully promotes hatred, the Supreme Court, in the same case, looked at the term willfully and deemed that it means intentionally, not recklessly. Moreover, it held that the word promotes means active support or instigation, not simple encouragement. Finally, for the offense of willfully promoting hatred, there are 4 available defenses. Among these is the defense of making statements that were relevant to any subject of public interest, the discussion of which was for the public benefit, if on reasonable grounds the person making the statements believed them to be true. These hate propaganda offenses do impose a limit on expression, but it is a very narrow limit. And this limit is demonstrably justified in a free and democratic society given the important objectives being pursued, namely to target extreme and dangerous speech that advocates genocide or promotes hatred against certain vulnerable groups. And this offence currently applies to a number of identifiable groups in Canadian society. All this bill would do is add gender identity and gender expression to this list. So just to turn now to consider any impacts the amendments to the Canadian Human Rights Act might have on freedom of expression. The Canadian Human Rights Act is concerned with protecting, for all persons, equal access to goods, services, and employment in the federally regulated sector. It is not concerned with regulating the expression of one's beliefs generally. And the Canadian Human Rights Act does not legislate particular modes of speech. To be clear, these amendments will not create any specific rules about the use of gendered pronouns. What the Canadian Human Rights Act does do is prohibit discriminatory practices, including harassment of employees and customers within the context of employment and other businesses within federal jurisdiction. Harassment involves speech or conduct that is persistent and serious enough to create a hostile or poisoned environment. If a reasonable person in the same circumstances would perceive the speech to be injurious, humiliating, or an insult to their dignity, then this could be considered harassment. These protections are already available on the basis of sex, race, sexual orientation, ethnic origin, and several other grounds. The amendments proposed in Bill C-16 would add explicit protection for trans and gender diverse individuals. Now I would like to turn to the objection that this legislation may introduce many gender identities. I have heard that this bill would introduce 70+ genders. This is not the case, and I am grateful for the chance to set the record straight. Bill C-16 does not define or legislate a particular list or number of gender identities. The bill is based on the recognition that not all Canadians fit neatly into 1 or 2 boxes, male or female, man or woman. I've also heard questions raised about why gender identity and expression are not defined in the bill and whether their meaning is too subjective. Gender identity and expression are now found in most, and soon to be all, as I said, provincial human rights codes. Commissions, tribunals, and courts have elaborated upon the meaning of such grounds in hundreds of cases in a reasonable way, with reference to the purpose of the law. Decision makers clarify these grounds, and indeed all grounds, through the application of real-life examples, allowing the law to respond to individual scenarios in line with its purpose. For comparison, I note that the ground of religion is also undefined, and one's religious beliefs are subjectively determined. However, as the Supreme Court of Canada has stated, protection depends on the religious belief being sincere, a requirement that tribunals and courts are familiar with assessing on an individual case-by-case basis. The same approach could be taken with respect to the grounds of gender identity and expression. I encourage this committee to focus on the real issue at hand. This bill is about ensuring equal opportunity for trans and gender diverse persons in employment and access to goods and services. It is about increasing their sense of security and freedom from the most extreme forms of hate speech. It is about denouncing what we know are still all too frequent acts of violence and other crimes that target persons out of bias, prejudice, or hatred. Surely we can all agree that these are pressing objectives and in urgent need of being addressed. Bill C-16 would make the amendments needed to pursue these incredibly important objectives. And finally, I want to acknowledge the courage and the leadership of the trans community, the decades of effort to achieve equality. Many are in the room today and are watching online, and I know some of you will testify before this committee. Your dedication, your resilience, and your tireless advocacy for equal rights inspire me. This is who we are as a country that embraces diversity, and I very much look forward to moving this substantive piece of legislation through as quickly as possible. Thank you for listening. I'm happy to take your questions.
Thank you, Minister. We'll move to questions, beginning with the committee's Deputy Chair, Senator Baker.
Thank you, Mr. Chairman, and thank you, Minister. I should congratulate you firstly on the excellent job you're doing in attacking some of the important issues that you are addressing, issues that should have perhaps been addressed many years ago. So my question and my supplementary, I'll put in all at once because the chair may cut me off when we get to the supplementary. He's a very judicious chair. First of all, coming from Newfoundland and Labrador, our Human Rights Act 2010 says gender identity, gender expression, section 9(1). The Nova Scotia Human Rights Act 1989, gender identity, gender expression. Alberta, section 4, gender, gender identity, gender expression. Ontario, 1990, gender identity, gender expression. BC, 1996, gender identity or expression. Northwest Territories, 2002, gender identity. Quebec Charter, gender identity or expression. And finally, PEI, gender identity, 1998. Saskatchewan, 1979. Prohibited ground gender identity. Manitoba Human Rights Code, 1987, gender identity. So my question to you is this, Minister. Why has it taken so long for the federal government? And perhaps this is an unfair question for you. I perhaps unwise to be adversely critical of previous administrations. So my supplementary question, I'll put it as very short. It's to your Deputy Minister, legal authority on these issues. Mr. Pentney, we've heard submissions concerning the use of washrooms or change rooms. Could you explain to this committee whether or not that comes under provincial jurisdiction, provincial law, which I've just quoted, going back to 1987, and even in federal buildings, could you comment on the jurisdictional question concerning those matters which have been raised at this committee?
Well, Senator, thank you for the history of the amendments to human rights legislation, and perhaps I can answer the first question. I'm happy to turn it over to the deputy to answer the jurisdictional question. Why has it taken so long? I am fully intent on focusing on the job that I have, our government has, and we as parliamentarians have at hand. If not now, when? And if not us, who? I very much hope that we will be able to move this important piece of legislation through, as I know that the legislatures of New Brunswick and up in the Yukon are doing at this time as well. But it is imperative upon us all, I would respectfully say, that we ensure that we provide protections against discrimination for individuals on the basis of their gender identity and gender expression to complete the circle of history that you have reflected on. I'm happy to turn it over to the deputy to talk about the jurisdictional question.
Thank you, Senator. Maybe just to supplement what the minister said, the history of human rights protection in Canada has been a history of evolution, and over time protections have been added and it's taken some time in provinces and the federal government. So the first modern human rights law was adopted in Ontario in 1960-1961 in recognition that criminal prohibitions hadn't worked, that the state needed to stand with victims, and that a commission using an administrative process with a combination of enforcement and educational tools could have an impact. The Canadian Human Rights Act wasn't adopted to cement that into federal jurisdiction until 1976. And in between, different provinces adopted different laws. And it's undeniable, looking at that history, that the adoption of the Canadian Human Rights Act has made a real difference to the lives of Canadians who operate within federal jurisdiction, federal employees, people who use banks, people who have access to airlines. That the adoption of the Act, as coming late as it might have been, has had a real impact in the intervening period. And I think that history is worth remembering.
So how about my question?
In respect of jurisdiction, very simply, Senator, as you know, property and civil rights are generally within the jurisdiction of the exclusive jurisdiction of the provinces, and so rules about accessibility, rules about washrooms, generally speaking, are governed by provincial legislation. Access to federal buildings is a more complicated endeavor, and the Canadian Human Rights Act provides that services ought to be equally accessible, and so there would be areas within federal jurisdiction. Indeed, I would note that the building, the washroom downstairs, would not be regulated, for example. The washrooms in this building would not be regulated by provincial jurisdiction, but the vast majority of those situations would be subject to provincial jurisdiction.
Senator Platt.
Well, thank you, Chair, and thank you, Minister, for being here. And I want to say at the outset that I think the goal for all of us is exactly the same thing. It's just a matter of some of us believe there's different ways of getting to that goal than others. But I certainly support the intent that you say this bill is supposed to have. I do want to correct two things, Minister, or one maybe, and then just one comment very quickly. There are significant differences between Bill C-16 and 279. They are not the same bill at all. And secondly, gender expression is not an identifiable group. Gender identity may be, gender expression is not. You can comment on that at the end if you wish. When we need gender identity and gender expression, or when we add it to the Canadian Human Rights Act, we are leaving definitions, parameters, and guidelines up to the Canadian Human Rights Commission to interpret. I'm sure you are aware that the Justice Canada website on the Q&A section of the page on Bill C-16 states, I quote, definitions of the terms gender identity and gender expression have already been given by the Ontario Human Rights Commission. This is the federal website. For example, the Commission has provided helpful discussion and examples that can offer good practical guidance. The Canadian Human Rights Commission will provide further similar guidance on the meaning of these terms of the Canadian Human Rights Act. Based on this statement of intent from the Department and the fact that federal human rights regimes typically mirror that found at the provincial level, it is reasonable to believe that the federal policy and guidelines will be similar to that found in Ontario. The OHRC has produced a policy on gender identity and gender expression and what constitutes harassment and discrimination, including refusing to refer to a person by their self-identified name and proper personal pronoun. That's a quote. Now, Minister, do you agree with that policy? And I'll just finish the question, Chair. If an individual, an intellectual dissenter perhaps, does not subscribe to the theory of an infinite gender spectrum, and what if that person does not believe that there are more than two genders? And this is simply talking about being more than two genders, not a person wanting to be the other gender. For personal, scientific, or faith-based reasons, do you believe they should have to refer to a person by a personal pronoun, and should failure to do so constitute discrimination?
Well, thank you, Senator Platt, for those questions. I'll try and I'll tackle them from the last to the first. As I stated in my remarks, one can't compel somebody to refer to somebody by way of a pronoun or otherwise. There's nothing within Bill C-16 that would compel somebody to have to call somebody by the pronoun he or she or otherwise. In terms of definitions, thank you for reading that excerpt. We specifically haven't defined gender identity or expression within Bill C-16. Having said that, as you note, or was noted in that quote, the Canadian Human Rights Commission, as well as other commissions across the country, have done substantive work in terms of engaging with the trans community and providing documents that further go into putting parameters around what a definition of gender identity or expression would be, as there are dozens, if not hundreds, of case law that speak to and further define the gender identity or expression. And certainly with respect to somebody's deeply held personal beliefs about their identity, this must be in a case where discrimination is alleged, dealt with on a case-by-case basis. And I would say in terms of gender identity and gender expression, as I said in my comments, gender identity is about how somebody seeks to identify themselves by their personal beliefs. That may be male or female, it may be both, it may be neither, and it recognizes the gender spectrum. In terms of gender expression, and if gender expression was, and this was a debate that has happened over the years, gender expression is equally as important to be contained within Bill C-16, as gender expression is the manifestation or the outward expression of an individual, what that individual chooses to wear in a workplace. And I firmly believe it's incumbent upon us as lawmakers to ensure that we provide for protections of individuals in terms of their gender expression. So as to protect those individuals in a workplace or any other federally regulated place, so that they can ensure that they can express themselves in a way that's appropriate for them.
So questioners and witnesses, I'd remind you we have a large number of senators around the table, limited time, so questions and responses, try to keep them as concise as possible. Senator Jaffer.
I applaud your leadership on this issue and on other issues, and obviously whenever you come to this committee, I'm very proud because you're from BC, so welcome. I want to say to the young people in this room especially, thank you for your leadership, your strength and courage in being here. And I know you're not just speaking for yourselves, you're speaking for other young people, so thank you for being here. Minister, my question goes it follows what Senator Platt was saying, I think, and you have covered it a bit in your remarks. You know, the Supreme Court of Canada has upheld the prohibition against willful promotion of hatred as a justifiable limitation of freedom of expression. And a member of Parliament said, and I quote, "I'm concerned that this bill would cause fear for many Canadians, fear that they would not be able to even discuss public policy issues such as this one, on which they may disagree with government-imposed agenda," close quotations. Minister, can you explain to this committee how this bill will protect trans people while protecting freedom of speech for Canadians?
Well, thank you for the question and the acknowledgement of the young people in the room. I would underscore and recognize the leadership that young people have taken. In terms of this piece of legislation, the purpose is to ensure that individuals' gender identity and gender expression is protected. In terms of concerns, and I did touch on it in my remarks around limiting the freedom of expression, I'm going to go through this and speak to it. In terms of the criminal code, hate speech offenses, they prohibit advocating genocide or other extreme communications of hatred. And as I said, with reference to Keegstra from the Supreme Court of Canada, hatred can be defined as covering only the most intense form of dislike. Expressions in good faith of a religious opinion, a dissenting view, or even an opinion that in some way may be offensive are not prohibited. And it's our government's position that with respect to gender identity and gender expression, that protection therein would be justified, and ensuring that we do provide those protections for individuals to ensure that they can express and be comfortable with who they are.
Thank you, Chair.
And the deputy wants to add something.
Sorry,
if I
just
could,
very
Mr. Chair.
quickly, I think I would urge the committee to look at what is actually being said and that might fall within the rubric of expressions of hate. Senator Dupuy and I served with the Commission, Canadian Human Rights Commission, and saw some of this up close. It's important to look at the words that might conceivably be caught with the criminal prohibition. They're calls to violence, and we know that violence is actually happening, that words have meaning. And so I would encourage you, in looking at the freedom of expression argument, to also look at the harder edge of this, which is some of what's being said on the internet, some of which is otherwise being communicated, because it is ugly. And if it was ever to fall within willfully, intentionally promoting hatred subject to a prosecution with the Attorney General's consent, it would be on such the extreme end of incitement to violence that I would just suggest it's a useful reminder, and I would encourage the Senate to try to explore the harder edge of this.
Can you provide to the clerk a sample of what you're saying so we can look? We have a short time span.
We can certainly draw from some of the existing examples so that you could see in previous cases the kind of language that's been found to fall within the prohibition.
Thanks, Chair.
Senator Frum.
Minister, when EGAL, which is Canada's national LGBTQ human rights organization, weighed in on C-279 in its original form, the predecessor to C-16, of course, EGAL's legal team asserted that gender expression is not only unnecessary to include, but in fact, they said it was constitutionally suspect. And here's what EGAL said. There is a risk that including gender expression in the amendments to the criminal code would lead to a constitutional challenge, and significant risk that gender expression could be struck down for being unconstitutionally vague or an unreasonable limit on freedom of expression for the accused, particularly in the context of the hate propaganda provision. In fact, the hate propaganda provision of the criminal code has survived charter challenges because it is not overly vague and was found to be a reasonable limit on freedom of expression in its current form. This argument would be much more difficult to successfully make with the inclusion of gender expression, which is open to many interpretations. Can you comment?
Well, just to comment on, I'm happy to have the deputy supplement my statements around gender expression, and thank you for reading from the EGAL report. I think that we need to be very mindful so as not to trivialize the rights that we're seeking to protect. Gender, again, and this goes back to my previous comments, gender expression has been advocated for among the trans community to ensure be included within this legislation so as to protect individuals in their workplaces and other places so they can express themselves how they deem appropriate. And in terms of somebody's gender expression, and this has to be considered on a case-by-case basis in terms of alleged discrimination, but the courts have, and the deputy can comment on this further, they look to sincere belief and again, that would be on a case-by-case basis, and we need to ensure that we provide those protections, and through the provinces and territories, their legislation, and through hopefully when ours is passed, that will be further expanded upon in terms of the court's decisions.
And I think we would respectfully disagree with Igal's position, because the criminal prohibition focuses on the intention of the speaker. And to the extent the intention of the speaker is that violence or hatred should be subjected to people because they dress differently, wear earrings, have other forms of what would be seen by some to be non-traditional gender expression, and the expression is so violent and so extreme that it might fall within the prohibition, we would expect a court to treat that very seriously, as they should, to interpret it very narrowly, and to put the Crown to a very high standard of proof, all of which is appropriate. It would be in that context that the constitutional defense, this wouldn't happen in the air, this would happen in the context of a real case. And one would think police wouldn't charge if there was doubt about whether or not it was sufficiently extreme, or whether or not it was sufficiently directed to the subset of the community that we think it's likely to be directed to, or that the Crown wouldn't prosecute, or that the judge wouldn't convict. So understand, again, in the air in a general way, in an academic kind of way perhaps, that debate about is the language precise enough. It will be in the application of the language we believe that the constitutional decisions will be made, and if the case is clear enough that violence was to be incited, that there was a call to violence, let's go out to a park and beat up ... that as long as the language was clear enough that we think it would withstand constitutional scrutiny. I would note that there's a variety of religious expressions, that people choose to live their religion and express it publicly in very different ways. And yet we've recognized that expressions of hatred against particular religious groups, notwithstanding the diversity of ways in which people live with their religion, has been found to be constitutional. And I would think that the same thing would happen here. Again, in an appropriate case.
Thank you very much.
Senator Ahmedvar.
Thank you, Chair. Thank you, Minister, for being here. I'd like you to address a common critique of this bill, that more rights for this group will therefore mean less rights for another. I don't happen to agree with that, but I want you to address the critique. I've heard, for instance, from a few women's groups who say this will infringe on the rights of women. Again, I don't agree with that, but I'd like you to address the critique from your point of view, and to tell us if within provincial jurisdictions, is there any evidence of adverse effects on other communities?
Well, thank you for the question, Senator. And the purpose of C-16 is to ensure that individuals can be free to be themselves without fear of discrimination. And adding gender identity and gender expression as a prohibited ground to the Canadian Human Rights Act, or as an identifiable group within the criminal code, adds to the already enumerated lists that ensures protection on the basis of a number of different categories. This is to add to that and ensure that individuals are free to express their gender identity and their gender expression without fear of reprisal or discrimination. I would further say that there's no hierarchy of rights. We need to ensure that we do everything possible, whether it's discrimination on the basis of being a woman, or discrimination on the basis of identifying yourself in a different way, that you have equal protections. That is the purpose of this legislation, is the purpose of the amendments that have been made over the years with respect to the Human Rights Acts federally and in the provinces and territories. I would submit that it does not take away or from protections for women. It adds to protections to ensure that we are filling the gaps that exist in the Human Rights Act as well as the Criminal Code.
Okay. Senator Dagenet.
Merci, Monsieur le Président.
Thank you, Mr. Chairman, and thank you, Madam Minister. I can see, do you have your earpiece in now? You can hear me? Okay, thank you. So thank you for your presentation and for being here today. I can see that this bill should be implemented right after royal assent, and that you are ready to move in that way. But I'd like to talk a bit about the measures that should be put in place to respect the provisions of the Act. And I'll give you an example. I'd like you to talk to me a little bit about Passport Canada. What's going to happen tomorrow morning if the bill is passed? What is going to be written in the passport? What kind of checks should be made before the passport is delivered?
The question, Senator, and without question, we, upon royal assent of C-16, we have work to do. And in terms of Passport Canada, in terms of the work that's occurring within individual ministries to recognize gender identity and gender expression. As I understand it, and preparing today, the Prime Minister and our government, working with Passport Canada, is looking at a third gender designation. That work is continuing. Likewise, work is continuing within other departments to see how we can update policies and the application of policies. And in doing so, we are committed to ensuring that we engage with the trans community to get their feedback, and operationalizing C-16 is something that will unfold necessarily so. And again, we do have work to do to recognize that simply ticking a box of male or female doesn't accord with the intent of what's in Bill C-16. So we're continuing with that work.
Merci, Madame la Ministre. Merci, Monsieur le Président.
Thank you, Madam. Thank you, Mr. Chairman.
I would like to come back to a statement made by the Honorable Richard Wagner, Supreme Court of Justice in Canada. He made that statement in March 9, 2017 at the Ottawa University Symposium on the Impact of 35 Years of Charter Adjudication. It's at page 7 of the Justice Wagner statement, and I read it. When the court eventually faces a question touching on transgender identity, these two propositions will provide essential frames of reference. One, that identity is not fixed but changing, and second, that identity is not innate but contextual. End of quote. When I read that statement made by Justice Wagner very recently, 2 months ago, I tried to, following the question of Senator Frum, to make the analysis of the two concepts of gender identity and gender expression in relation to those two criteria. Do you find that in gender expression, you will have essentially the aspect of moving identity, the fact that identity is changing, and then that identity has to be defined in a contextual reality. So could you give us your interpretation of how Justice Wagner two criteria would be found in the two concept of gender identity and gender expression, because it seems that the Supreme Court, as much as Justice Wagner was speaking when the court eventually, he didn't say when I will be faced, he said the court, how much we can weight those two criteria in the definition of gender identity or gender expression.
Well, thank you for the question, Senator, and I'm happy to make some comments, and then again, my deputy can follow up on further comments with respect to Justice Wagner's comments. In terms of the changing views of gender identity or the possibility, the purpose of this bill is to ensure that individuals can identify themselves from the deeply held personal views that they have in terms of their gender identity, and then protection for the manifestation of their views, however that might express itself. And the the belief that over time, perspectives or the identity may change. The court will look at the sincerity of those beliefs or that identity and that expression and take that into consideration in terms of what they're going to be and having discussions about. But what we want to ensure, and I think that it's a positive reality of the ongoing conversation of elevating and highlighting the reality that trans individuals in this country face, is that we're having this discussion and that it's okay to express yourself in a different way, and that we're providing the forum or the environment to continue these discussions is a really positive thing. So individuals that may or may not have felt compelled or comfortable with articulating how they identify themselves may feel more comfortable to do so now. Deputy
So, thank you for the question, Senator. And Justice Wagner's speech obviously was an exploration of the meaning of identity in a diverse society. He was not speaking obviously in a decision, and whatever he was signaling about where the future court might go in a future hypothetical case on particular circumstances, having heard evidence and argument from all sides, I think we should understand that his was a personal expression of a general concept. Core to the evolution of human rights law in Canada, our understanding of equality has been an evolution from things which are seen as innate to other things, which were core to a person's identity, core to their vision of themselves, and should be changed not by virtue of employer or service provider or state coercion, but by virtue of their choice. So we said a long time ago as a society that employers shouldn't fire women because they choose to get married, and that's what was happening. Not men, women. They said they shouldn't fire women because they, quote, choose to become pregnant. That they shouldn't fire or refuse to hire someone because they've chosen to express their religion or not to express their religion. And to the extent that those things all can change in one's life as one matures and evolves, what we've said is that we as a society believe those are protected spaces. The choice should be the individuals, not the states, not the employers, not the service providers. That we should be neutral to that and let people live their lives as they choose and wish to be. That's what this law would say if it was adopted by Parliament.
To jump in there, we've got 5 senators on the list, about 10 minutes remaining. I know it's a challenge, but I suspect some are not going to get a question. Senator Batters.
Thanks very much. Minister, this is actually in 18 months the first time you've been before our committee on a government bill on your own. With C-14, you appeared with the health minister on that particular one. And I again want to echo what Senator Plett said earlier. This particular government bill is not the same as the private member's bill that we dealt with in the previous parliament. This Liberal government bill does not only include gender identity as a protected ground, but also gender expression. And I think many Canadians watching this today will be surprised to learn that. And I want to go back to the Egal Canada memo that was provided on the previous bill. And also in that, they wrote, quote, "It is unlikely that the omission of gender expression within the criminal code hate crime sentencing provisions will have any impact, given that the courts are already entitled to consider any other similar factor in sentencing, which could include gender expression." So I'm wondering why you would include gender expression in this particular bill when there's no consensus on a definition of gender expression. So, Minister, what is your definition of gender expression, and why didn't you include it in this? Without a definition, the term remains very vague, as we've heard today from you, and particularly in those sections of the code related to hate speech. And I'm also wondering if you would please table today a charter assessment that demonstrates that using gender expression has only, as your assessment shows, a very low risk of having this bill being declared unconstitutional. And given that potential risk, why would you include it in a criminal code amendment, an expression that is so very vague?
Well, thank you, Senator, for the questions. I'm very pleased when as I do with all justice bills, when I table a bill, I also table a charter statement. I am happy to have my officials provide that charter statement with respect to Bill C-16 to everybody on this committee. In terms of definitions, for the most part, in all of the human rights legislation across the country, there aren't a lot of definitions contained therein. There are some prohibited grounds that are identified, for example, around disability, but we are not and sought not to define identity and expression. The same is true with respect to provinces and territories. Gender identity and gender expression are now explicitly recognized in Alberta, British Columbia, Newfoundland and Labrador, Nova Scotia, Nunavut, Ontario, Prince Edward Island, and Quebec. Again, in terms of gender identity and to your question, gender expression, we want to ensure that we fill the gaps that exist in terms of protections for individuals that may identify themselves beyond what's considered normal, but we provide a spectrum for individuals to identify themselves and to ensure that in an environment, whether it's an employment environment or otherwise, that they're not discriminated against based on their gender expression. I would not seek to put a definition around gender identity or gender expression. That work, as I said earlier, is an ongoing process. Canadian Human Rights Commission has done a lot of work in terms of putting the parameters or the discussion that has occurred around on case-by-case basis in terms of identity and expression. Likewise, the courts in many, many cases have further helped to define the space, and I know that will continue as unfortunately cases are presented around discrimination.
And of course, much of that has occurred without this bill being in place. Thank you.
Senator Dupuis.
Merci, Madame la Ministre.
Thank you, Mr. Chairman, and thank you, Minister, for coming to meet with us and to confirm with us that your government has the intention of protecting people who have been appearing before committees for at least 20 years. And back in 1999, on the Human Rights Committee, many young people, young adults, who said very clearly to us that the discrimination that they were suffering was based on what they are and who they are. And in that sense, I think that it is extremely important that all of our achievements, and I'm speaking to the children present here in the room, and the Francophone children who are trans, who appeared before us on human rights, who have real problems at school, who have real problems having their numbers registered in the official documents. And I'd like to know from you if you agree with the fact that has been an extremely important paradigm change when we decided to create human rights legislation to protect people in who they are when given discrimination.
I completely agree. I think that with respect to Bill C-16, as with respect to additions to prohibited grounds and identifiable groups, we as a society change and evolve over time. And as Minister of Justice and the Attorney General of Canada, and I believe as parliamentarians, it's incumbent upon us to ensure that we live in a country that embraces diversity. We are rich because of our diversity, and we need to ensure in every way possible that people have the ability to live and express who they are, and that they will be protected in doing so. And by virtue of that protection, individuals will be able to achieve, if they work hard, whatever it is they want. And I'm extremely proud to be able to have tabled Bill C-16. I will be extremely happy when it is passed.
I'd like to get the remaining questions on.
Thank you, Senator.
Senator Pate.
Thank you very much, and thank you, Minister and officials, for joining us today, and thank you for your leadership in so many areas and the indication of where we're headed with some other things, and appreciation for this work you're doing in terms of ensuring human rights protection for all Canadians. My question is a more strategy in terms of, as you know, we've been very interested in discussing other criminal justice reforms and areas where sentencing and exercise of judicial discretion are going to be examined. And so I'm curious as to why you decided to add aggravating factors into this bill instead of, as in a number of other areas, you've indicated you're waiting for the more comprehensive criminal law reform process to be unfold.
Well, thank you for the question, and certainly I look forward to engaging with this table on the broader criminal justice reform that we're undertaking, and including making substantive revisions to the criminal code, some of which is already in process. This was adding gender identity and gender expression as an aggravating factor in sentencing goes part and parcel with adding it to prohibited grounds and identifiable grounds within the criminal code. This is something that has been advocated for by the trans community. This is something that has been substantially advocated for by other parliamentarians who have taken leadership roles in this regard. It presents and completes for consistency in the criminal code the reality that we're identifying or adding gender identity and gender expression, not only to it be an identifiable group, but that in sentencing is certainly an aggravating factor that should be considered by a judge.
Final question, Senator Sinclair. Thank you. Thank you, Chair, and thank you, Minister, for being here. And since we don't have any difficulty understanding what freedom of expression means, I commend you for not trying to put a definition on the word expression in this bill, because we shouldn't have to define a common sense word. But I do want to ask you, in the recent past, many of the provinces that have transgender and gender expression protection in their legislation have allowed people on their driver's licenses to mark an X in the gender box, if I can call it that, on the driver's licenses. Ontario, for example, just last month, I think, did that. And so I wonder if you have undertaken an area, or will be undertaking an area of education of people within the civil service or public service and the general public to communicate that kind of option that might become available.
Thank you for the question or the comments and the question, Senator. As I indicated a bit earlier, it is the Prime Minister is very mindful of the need for perhaps a third box or an ability to mark something other than male or female. This work is being undertaken at Passport Canada. Individual ministers and within their departments are recognized that this bill has been introduced, that there is work that needs to be continued to be taken, and again, I think broader discussion and education around the purpose of gender identity and gender expression, Bill C-16, is very important, and it's something that we're going to ensure that we continue to engage with the trans community on how we can most appropriately give expression if and when this bill receives royal assent. Continue to work with them, but also continue to ensure that we elevate and maintain the discussion around human rights in the general Canadian public, because it's important to ensure that we have that education and understanding to ensure we eliminate discrimination as much as possible in the reality of some of the challenges that individuals are living with.
Thank you, Minister. Deputy, Ms. Wright, for your appearance and testimony, and we are now going to suspend briefly before hearing from our next panel.